Good morning, ladies and gentlemen. If we are ready, we can commence with the proceedings. I would, just for record purposes, ask the representatives just to place their names on record, please. And can we start on this side of the table and just go around? Ms. Tenga.
Yes, I am the evidence leader. I'm Ivy Tenga, the DPP for Limpopo, and I have taken over from Advocate Koli Kanyile, who is a former colleague of mine, was nominated as evidence leader, and I've taken over. Thank you. I'm assisted by Advocate Mutlala.
Thank you. Good morning, Chairperson and the honorable members of the panel. My name is Tan Dinomen. I'm assisted by my learned friend, Mr. Matebese, who's sitting on my right. We are instructed by the State Attorney Kimberly. We represent the two justices, Justice Nkabinde and Justice Jafta. Thank you.
I confirm, Mr. Chairperson. Thank you, Judge.
Chair, I'm Gilbert Marcus. I appear together with my learned friend, Mr. Musi Sikakani, on behalf of the judges of the Constitutional Court, apart from Justices Jafta and Nkabinde. I'm instructed by Mr. Dulam, who's on the extreme left, of the State Attorney, Johannesburg.
Thank you.
My name is Taban Masugu. I, together with Mr. Sitagi on my left, appear for Judge President Hlophe. We are instructed by Bikulu and partners, and Mr. Kulu is on my right and his associate is on my left.
Thank you. We have to deal with a complaint which was made against my colleague, Judge Musi, and Judge Musi has an announcement to make.
Thank you, Chairperson. Sorry. This morning I received a notice of motion with an affidavit by Judge President Hlophe applying for my recusal in this matter. Essentially, the allegation is that during July 2017, at Zimbali in KwaZulu-Natal, I discussed the matter of Mulawudzi versus Old Mutual Life Insurance Company Limited, a matter that was decided by the Supreme Court of Appeal, in which a decision by Judge President Hlophe was set aside. The allegation is that I, at that occasion, said words to the effect that I was not surprised that he would act in the manner described in the judgment of the Supreme Court of Appeal, as that was consistent with his controversial character. On the 21st of May 2018, Judge President Hlophe called me on my cellular phone and inter alia requested me to recuse myself. At the time, I told him that I'm not prepared to do so, and that a proper application for my recusal will have to be made in front of the tribunal. I denied all the allegations made. On the 22nd of May, I phoned my fellow tribunal member, Ms. Pether, because I could not get hold of the chairperson. He was unfortunately overseas at the time. I then had a discussion with her and informed her that I think the habitat for a recusal application is indeed the tribunal, and that we should discuss the matter. On the 22nd of June 2018, Judge President Hlophe's attorney wrote to me personally, again requesting my recusal, and also informed me that they are going to send the letter to the Chief Justice. For what purpose, I still don't know. It still escapes me, because the Chief Justice is not a member of the tribunal. But be that as it may, I then wrote to them on the 26th of June, informed Mr. Kulu, one, that I acknowledge receipt of the letter, two, I have considered the contents thereof, and three, that I am not prepared to recuse myself. I did not state any reasons why I am not prepared to recuse myself. I was then this morning given the affidavit, which alleges firstly that Judge Hlophe called me in June 2018. That is incorrect. He called me on the 21st of May. Secondly, the affidavit alleges that a particular judge whose identity is unknown is prepared to make a statement to that effect. Unfortunately, the affidavit by Judge Hlophe, Judge President Hlophe, relating to me is entirely based on hearsay evidence. There is no direct evidence whatsoever. The furthest that the affidavit goes is that the particular judge will be prepared to make a statement at some future time. As the chairperson has just indicated, I was also informed this morning that this affidavit forms the basis of a complaint against me. Now, two things about that. The mere fact that there is a complaint against a judge does not disqualify the judge from sitting in a matter. There is ample authority for that proposition, both in this country as well as internationally. Otherwise, legal representatives will go forum shopping. All that you then have to do to disqualify a judge would be to lodge a complaint against the judge. Now, that is totally untenable. However, having considered the manner in which this whole issue has unfolded, the fact that Judge President Hlophe called me and made certain ex parte communications with me without having the other parties there, the interest of justice, and obviously the interest of the judiciary. I do not think that our judiciary needs this at this stage. I have therefore decided that the best course in this matter is for me to recuse myself so that another judge should be appointed to deal with the matter. I therefore formally recuse myself from this matter.
Sorry, can I make a response to what Judge Musi has just said to the public?
Yes, you may.
There are far-reaching remarks that are made by Judge Musi relating to his comments. Firstly, Judge Musi still doesn't deny that he can I finish, because I'm now addressing the panel. Judge Musi does not deny that he had that conversation with other judges in which he spoke in disparaging terms against the JP. He doesn't deny that even in his statement. Secondly, he picks on an era of a date in June and makes a significant issue on it. It's not. This is not a. We're dealing with constitutional rights here. We're not dealing with conversations in informal conversations in retreats. It's unbelievable that Judge Musi's conclusion to recuse himself should be preceded by such a statement that seeks to present him as somebody who is not disqualified from making from presiding in this tribunal. It's untenable. It's wrong. it's absolutely wrong. It justifies why he should not be sitting in this tribunal. It's wrong. We would have wanted to cross-examine him on some of the things that he says here. Hlophe called him as a colleague. That's what he instructs us. He says, look, it's happened before that judges talk amongst themselves. And I just wanted to hear from him. Notionally, Judge Musi could have said to him, look, I mean, it was nothing. You shouldn't worry about it. I mean, I was really not meaning much about it. Now he says, and it's now in dispute. We don't need to present, we do not need to tarnish these proceedings with controversy after controversy. It's wrong for Judge Musi to deal with this matter like this. Normally, we should have asked for your recusal. Not you coming here to make a statement and making expert statement that when we don't have a duty to disqualify, to cross-examine you, it's just wrong. Because Judge Hlophe is represented here. We've brought an application for your recusal. You come and make a statement and then you make expert evidence on what, how do we deal with what you've just said?
I'm sorry, there is a recusal, and I don't want this to end up in a factual dispute at this stage.
There is already a factual dispute to respect.
Okay, well, it can be dealt with at any later stage, not at this stage. As far as Judge Musi is concerned, he has accused himself. I know that there was a letter in which he formally denied the allegations.
Sorry, he didn't deny the allegations.
May I just assist the chair? In the letter written to me by Mr. Kulu, paragraph 2.4 thereof reads as follows. Our client has established that you indeed uttered disparaging remarks of and concerning him in the presence of approximately 6 members of the judiciary. Your denial to him to having made such disparaging remarks. Now, I do not know. His attorney, Judge President Hlophe's attorney, says it, that I've denied it. Mr. Kulu probably has the letter. But I do not think it is necessary for me to go into it any further. But here is the letter. Mr. Kulu is right next to you.
Can I just close my presentation?
And make it short.
Yeah, make it short. I appreciate Judge Musi's final decision to recuse himself. He's disqualified from sitting in this tribunal because he has given us the assurance that the tribunal may proceed with a fair and independent-minded people. We appreciate that, and I make no lightness out of recusing himself in public as he has. What I do find quite unsatisfactory is the statement that precedes it, because it creates again a basis for controversy to continue on the Judge Hlophe's tribunal. But that said, we appreciate that you have taken that decision. We make no further. We're prepared to make submissions on his recusal.
Well, thank you
but
very much.
all the law that I had brought together, and all the submissions and all the beautiful statements I was going to make in support of the recusal are now going to be just water under the bridge. He stole my thunder, and that's why I'm a bit upset.
I take it that no one else has anything further to say about the matter.
Thank you, Chairperson, Judge Labuschagne. From my side, I am just concerned, and my concern take me to refer the Chairperson to the decision of the SCA, a decision by Judge Nafsa. From our book 2, at page 918, it says, one final aspect requires consideration. The considerable delay in the finalization of the complaint in a matter which is of crucial and national importance does the judiciary great harm. And then the judge refers to section 27 of the JSCA, and I don't know if you need me to read it, but it's a well-known factor. And I also want to further refer the chairperson and the deputy chair to the decision of the full court, the constitutional court, where there was a unanimous decision in that court that The relevant part which I want to refer is page 941 from the same book, book 2 of our bundle. It is line number 29 on page 941, which says, 8 years later, the matter has not been finalized. It is in the interest of justice that this matter brought to finality. So my request is, Chairperson, whenever we find another date and another replacement for Judge Musi, we must never take too long, because there might be other issues that might also still delay us. And therefore, I'm asking this Chairperson to make a final decision on whether the next time when we meet, we need to really finalize this matter. And I must also mention that both Judge Nkabinde and Jafta are here and are ready to proceed and testify in this matter. And it might happen that later on during the year, they are not available, and it will be such a sad day to still postpone the matter unnecessarily, which is of this national interest, as I've indicated. And I must also indicate to the judge, the chairperson, they are the witnesses, or the witnesses, as I have indicated, are ready to proceed today. Yes, and I'm asking for the final decision, the final say as to whether the next time we meet, we need to finally proceed with this matter and finalize.
Thank you,
Thank you.
Ms. Tenga. I can only agree with you. This matter has been delayed for a very, very long time, and I personally am very anxious to finalize this matter, to get to the merits of the matter and to deal with therewith. And I will personally phone the Chief Justice and request him to make another appointment as soon as possible, and then we can arrange a meeting and arrange a final date. And I'll insist on a final date. I want to apologize to the witnesses who are here. It's unfortunate, but it's something that I cannot control. And obviously they are excused from further attendance at this stage.
Chairperson, I just want to check, will it be perhaps this month, because one of the judges will be going on a long leave and might not be available from the 1st of August. That is very important.
I think because of the investigation, we have always tried to arrange a hearing in the vacation time, because representatives, advocates in particular, are very busy otherwise, and I will try and expedite this matter as much as I possibly can, but it will probably be during vacation.
Chairperson, can we respond? Firstly, Judge Hlophe is ready. The last time we met, you recall that he was there for a week, and we waited for a week to have the evidence read. But secondly, we're addressing you. You're incorrect. You're not a correct tribunal to even receive submissions that are being made by my learned friend. There is no tribunal that's sitting here, because you're not correct. So we would want to be understood. We don't want to be understood to be resisting the principle that this matter should have been resolved a long time ago. We are anxious to have the matter resolved as expeditiously as possible, and we are grateful that you are making the undertaking to ensure that that happens. But what we will not compromise is our right, the right of each party, to a fair, independent tribunal. Should there be another issue that arises as a result of whatever else, if the chair should speak to some other judge somewhere, and we get to hear that you have said some things that are not, we will ask for your recusal in the next hearing.
We'll promise you. Promise you, I only have 7,000 words a day, and I'm not going to waste it.
I appreciate that. So we do want to say that an impression should never be created that we are bringing frivolous applications or
Right.
we're delaying things and we are not sensitive to the expedition. Hlophe has suffered great prejudice as a result of this tribunal dragging on.
I accept that, and I also accept that it is also in his interests
Yes.
to get this matter finalized.
Yes.
That's
From
always
an
been my
independent, fair, and impartial tribunal.
attitude. Yes.
Thank you.
In any event, this tribunal is then postponed sine die, and we'll try and arrange a date at a later stage.